Hello and welcome to Judicial Process, Chapter 1, Law, Courts, and Politics. In this chapter, we'll be dealing with different topics such as courts and government, courts as legal institutions, courts as political institutions, and courts and controversy. First, let's think about courts and government. This class is a class on the judicial system in the United States of America, and so it's a subset of political science. Political science is the systematic study of government and politics. When we think about courts and government, we need to understand that courts are the third branch of government. Courts are different from and similar to the other branches of government, those branches being the executive and legislative branches. Judicial process discusses the legal and political characteristics of law and courts. You might be surprised that we're going to address not just the legal, but also the political characteristics of law and courts, because sometimes we tend to think of the judicial branch as that branch which is outside the political process. One thing you'll learn in this course is that the judicial process is a political process as much as it is a legal process. In the United States of America, courts are charged with interpreting constitutions. Judges on the U.S. Supreme Court interpret the U.S. Constitution. You may think to yourself about the pivotal case Roe versus Wade, decided in 1973. At the recording of this particular lecture, Roe versus Wade is coming under review by the Supreme Court of the United States, and it appears, based on a leak of a draft opinion, which was an unprecedented event, it appears Roe versus Wade may be overturned soon. Judges not only interpret the U.S. Constitution, but judges on state Supreme Courts interpret the state constitutions. Courts in the United States are divided along federal and state lines. The relationship between federal and state power is frequently a relationship cloaked in controversy. The United States Supreme Court can declare any law unconstitutional. Sometimes these laws are state and local laws. Here we may think about the Brown versus Board of Education case, a case decided by the United States Supreme Court in 1954, in which the Supreme Court of the United States declared a Topeka, Kansas law unconstitutional related to the segregation of races in education. Controversial decisions continue even today, including death penalty restrictions, or the case I just mentioned, which is coming out of Mississippi, where the Supreme Court of the United States may be using a Mississippi law that restricts abortion to 15 weeks or earlier to overturn the Roe versus Wade decision of 1973. Let's take a moment to think about courts and the executive branch, which is one of three branches in the United States system of government. Presidents view the courts as part of their political agenda. Presidents appoint judges and lawyers, and their lawyers, the president's lawyers in the executive branch, bring cases and defend the president in the courts of the federal government. So there's frequently disagreement about who should be the final judge, and there's frequently tensions between the president and the courts. You may think about the importance of presidential elections as it applies to the selection of justices, especially justices on the Supreme Court of the United States. You might think about President Donald Trump or President Joe Biden and the effect they've had in being able to appoint Supreme Court justices. But you also need to be thinking about president's influence in appointing justices in lower courts, courts of appeals, federal district courts, and so on. Governors and mayors also use the courts to advance their policy objectives. So in the state of Texas, for instance, judges are elected. However, when vacancies occur, the governor of the state of Texas appoints justices or judges to those positions. In the state of Texas, the district court and court of appeals and Supreme Court are elected, as I mentioned, and they are filled by candidates who run under political parties. So in that sense, a Republican governor of the state may be better aligned with Republican judges in any given jurisdiction. That's what happens in the state of Texas. Not every state is that way, but it's something to keep in mind that courts do function in political ways, both at the federal and state level. Courts and legislatures compete for institutional balance. So you might hear in the news about laws that are passed by Congress that come under judicial review by the courts, and you can see the political ramifications for that. Courts interpret and question the legality of legislation. Courts review legislation in light of the Constitution and makes judgments on those statutes and laws passed by Congress. Legislatures, on the other hand, control the jurisdiction and budgets of the court, and so influence the composition of the courts. Courts are frequently involved in election controversies. Courts have decided what candidates may say. In the 1992 case, Republican Party of Minnesota versus White dealt directly with this question of whether candidates can say certain things. They also address questions of how much can be spent and many other election laws. You might think in terms of the election laws, you may be thinking about cases involving election finance. Who gets to spend what and on how much? They also decide how votes will be counted. Here we might think of Bush versus Gore, the presidential election of 2000, where the Supreme Court of the United States made decisions and judgments related to Florida's counting of ballots. Elections affect the judiciary too, and most judges are directly elected by voters at the state level, including in the state of Texas. That's not true at the federal level. Federal judges are appointed by the president and confirmed by the Senate, but in the state of Texas and other states, judges are elected. Political parties are interested in having their partisans appointed to judgeships. As I mentioned, the federal judicial nominating and confirmation process has become very partisan. We see that even in the most recent appointments to the Supreme Court of the United States. State judicial selection systems may be heavily influenced by partisan politics, even though judicial selection itself is supposed to be nonpartisan. Interest groups are a powerful force in American politics, no less so in relation to law and courts. Interest groups file lawsuits, they donate money to judicial election campaigns, and they issue statements about how they think the law should be interpreted and cases decided. You might think about religious liberty interest groups in particular. The Becket Fund or the Alliance Defending Freedom are incredibly influential interest groups, both in the judicial and the political system. Courts depend greatly on their legitimacy. Courts must have credibility in order for the court to be able to issue judgments and those judgments to have any sort of influence in our government system. They possess neither the purse nor the sword. They need public support in order for their judgments to be adhered to. So does public opinion affect the judiciary, or does the judiciary affect public opinion? Well, the jury is one link between courts and public opinion. Judicial Process, this book we'll use in this class, examines the makeup and the procedures and the decision-making of juries. The media determines also how much of what we know about judges, juries, lawyers, and litigants. So the media has an incredible influence on court systems. Questions like, should cameras be allowed in the courtroom? Is a fair trial possible in high-profile cases? These are questions that are made only harder by media. And of course, media is no longer just TV shows or corporate media, but social media has influenced the court system. The popular media also affect what we know or think we know about the judiciary, about judges themselves and lawyers. So we think about shows like Judge Judy or CSI or Law and Order. These shape the opinions of the public. When you hear the word law, you might often think of courts, but a court system involves much more than law. The legal system encompasses an array of governmental institutions, key actors, and other participants. We might think of courts as legal institutions in three concentric circles. First, the inner ring, institutions of law. The innermost ring is made up of the institutions of law, or law and courts. Law is a body of rules enacted by public officials, the legislature or Congress, and backed by the force of the state, or we might say the force of the sword, the executive branch, who enforces the law. Courts are places where judges work, where judges rule on certain disputes and legal issues that come before them. Courts decide disputed issues based on the law. All three branches of government are involved in deciding what the law is: the legislative, the executive, and the judicial branch. So for instance, the legislative branch might pass a statute. The executive branch may issue regulations in enforcing that statute, and the judicial branch may hear disputes involving that statute. Courts do not just decide law, they make the law too. They're involved in fitting law to the needs of a dynamic society. Did you know there are more than 17,000 courts in the United States? The middle ring, and when we think about courts as legal institutions and concentric circles to explain that, we have the inner ring, and then there's the middle ring, the interpreters of law. The interpreters of law include primarily lawyers and judges. Lawyers interpret the law to their clients and are the principal gatekeepers of a legal system. Judges are society's authoritative interpreters of the law. How they are and should be selected is a source of constant debate. Then there's the outer ring of courts as a legal institution, and that's the consumer of the law. The consumers of law are the thousands of citizens that call the police, file a lawsuit, join interest groups, and so forth. They provide the raw material for courts to hear disputes and to determine what the law is. Some consumers are individuals filing lawsuits. Other consumers may be interest groups or businesses bringing disputes before court. These circles of the legal system are constantly interacting with other variables at play in our society, whether that's social or economic or political forces that may be at work within the United States. For instance, social attitudes about marriage have changed over the years, and so we ended up with the Obergefell decision and the Windsor decision that gave us same-sex marriage. September 11th, 2001 changed views about terrorism, and the political and economic demands affect courts and affect the businesses involved in bringing disputes before the court. Howard argues that courts are bifocal. They're both legal and political. Courts are clearly legal institutions interpreting and applying the law, but the law is often imprecise, and so courts are clearly political institutions too, allocating values for society across our legal system. So how are they the same, and how are they different? Well, politics is the authoritative allocation of values for a society. The judiciary is clearly political under that definition. Court decisions are determinations that settle controversies. They're authoritative, they involve discretion, and they determine winners and losers. But how are they different? Well, the operations of courts differ from those of other governmental bodies. Courts are passive and reactive. They must wait for a controversy to be brought to them, a dispute to come through their doors. Judges make decisions in cases that are brought before them. They do not issue on their own rulings about disputes that are not before them. The judiciary is more insulated because they're not open to elections, at least at the federal level, and they're certainly not open to lobbying like congressional offices may be. But then again, you may think about interest groups who write amicus curiae briefs before the court. It's a type of lobbying in a sense. But generally speaking, the judiciary is more insulated from the legislative and executive branches. Let's take a moment and think about courts and controversy. The courts have a major impact on the U.S. political and social landscape. So Alexis de Tocqueville, a great French philosopher and historian who traveled the early American Republic, once said, "There is almost no political question in the United States and that is not resolved sooner or later into a judicial question. Once again, there is almost no political question in the United States that is not resolved sooner or later into a judicial question. Controversial issues are constantly brought before courts. Differences of opinion on these issues is often linked to a partisan position in your politics. The courts today, they're frequently involved in deciding social policies like same-sex marriage, healthcare, religious liberty issues, or as I've mentioned already, abortion issues. They're involved in making criminal justice decisions, the death penalty, gun control, drug policy, and they're involved in civil justice issues like tort reform, product liability lawsuits, or tax disputes. In conclusion, courts are legal and political institutions. The definitions of law and politics are very similar, but they're also different in the way they function in the court system. Courts operate in a political environment even as they issue forth their legal opinions. Judicial process, the text we're using for the main part of this class, is about the intersection of law and courts and politics in the United States.